everybody. And as you well know, this is very much in unprecedented times for us all. And for our part in BITA, we'd like to continue to show our strength, strength in understanding, strength in communication, and of course, strength in community. So this portal is designed to assist our members and allow us to speak and answer the questions that are unanswered and create some general awareness. Every day is now a skill day, and we recognize the unique challenge that COVID-19 presents. We want to help our community to answer the questions in the crisis that are raised on a daily basis. Our members are pulling together to offer their expertise via online video conferencing to provide you with the advice and answers to the questions in real time. So going forward, your feedback and concerns raised will help us dictate the subject matter for these video conferences in the coming weeks. This is time for solidarity, and this is time for calm. BITA continues to be as we are, and BITA is yours. So I'd like to introduce Henry, if he's here now, for this session about the legal end of and aspects. So welcome, Henry. The stage is yours.
Hi, Henry Hathaway is my name, and thanks very much, Paul, for that. I've just had a message from Diane that if everybody can please use the chat function at the bottom of the page to ask questions throughout this webinar. As many of you probably will know, but just to introduce myself, Henry Hathaway is my name. I'm a partner with Silver Shemmings Ash. Delighted, and it's actually as a result of the British and Irish Trade Alliance to actually have this opportunity to start, like, no, we advocate quite a number of times with seminars, reaching out on different topics, and it was actually BITA's idea to run these points. So throughout the course of the events, we're talking about the effect of COVID-19, the effect of the coronavirus, in terms of construction contracts specifically, and a lot of the questions that are relating to, of course, what is the contract, what's the effect, what's force majeure, and therefore we now start thinking about what are the effects. So a lot of the last number of days, a lot of the phone calls I've been getting from existing clients, and the phone calls have been ranging simply around what if the actual contracts can't be performed? What occurs if they become more difficult? One particular call today was that there are quite a number of problems starting in terms of what is the actual events in relation to supply chains. There is an increased number of difficulties we're being told in relation to supplies, people in general, the labour workforce, and how did those effects actually arise. So these are new things in a lot of different ways, but what I can say is that the law has actually generally dealt with these items for quite a long time. Back into 1903, all of these events have occurred back into 1943. So the law is fairly well established. It's a matter of actually taking what the current law actually stands against how it actually is to be applied in their current position. And a lot of events, people will say, well, the current pandemic is not, it's not foreseeable, or indeed it's not a frustrating event, or it ought to be a frustrating event, or it ought to be a force majeure. But if we actually look at what a force majeure is not actually, it's a French doctrine. It's not in actual fact dealt with under English law terribly well, or at all. So now, what are the effects? And if we turn to the likes of the JCT, design and build contracts, ordinarily what you'll have is a force majeure is an event that's a relevant event. So inherently, you're entitled to time, but it's not a relevant matter, which means that you don't actually receive on your costs. Now, of course, express drafting will actually take care of those different points. But if we go into, again, separately, and I'm just going to refer to some notes that I've made, when we actually suggest against NEC 4, there simply is no dealing, perhaps, which neither party could prevent and which could not be reasonably foreseen at the time of contract. The contractual notice requirements then become very, very important. But if you're lucky enough to have the type of express wording that might actually give you that indication, it might give you that gateway, if you like. But ordinarily, if we go back to, if force majeure is something that is expressly stated, how those events different happen, and essentially the contract cannot be performed. Remember, in all of these instances, the courts won't be interested in whether or not the projects were delayed. They're not really interested whether people have, suffered loss, because those inherent provisions are underneath the contract anyway for recovery. So, for example, the subject matter, if we want to go away from force majeure, and now we're going to look at, is a contract frustrated? Now, a contract being frustrated does not mean that parties are frustrated. What it means actually is that inherently the contract itself is frustrated. So a good example would be back in 1903, King Edward the Seventh, I believe, was supposed to have been given a procession. He became very ill, and he couldn't actually make the procession itself. There are tickets sold to see that procession, but he was the subject matter. That's why people actually turned up to that. That was called a frustrating event. And secondly, if the subject matter is destroyed, and we go back to old cases like that. Now, in these instances, the way the courts would generally say, or inherently the contracts have not been destroyed. They are capable of being performed. Therefore, on the back of that, even though they might be delayed, even though there might be costs incurred, the subject matter is not destroyed in itself. Contract is capable of being performed, but the difficulty is it might cost more and certainly have more time related to it. Now, this is going to present quite a number of challenges. One particular phone call I had today, which lasted well over an hour and a half, was in the event that we're talking about labor shortages. We're talking about supply chains, drivers not being available even for concrete, for materials. Muck away was one issue that came away from those different instances. And the brutal honesty about it is that those events could occur for any different reasons. Now, why is, say, for example, force majeure not going to crowd in? Why is it going to be an issue? People are talking about an act of God. And if we actually see what is an act of God, we're thinking about earthquakes, we're thinking about all of these different points. There's an argument raging in the background as to whether or not coronavirus is an act of God, and it most likely will not fall under that. It's a pandemic, whether or not there's human interactions or certainly all of those points, but it's very unlikely that will be seen as an act of God. And these are the difficulties that are faced. By the way, and I'd just like to say that Diane Birch is moderating in the background, and as you have questions, please do raise them as we go through. But it's very unlikely, unless you're very, very lucky, that the pandemic will be part of the contractual redress. And that is something, if it is, you ought to check. What is more important, really, and what more likely, and when I was watching Boris Johnson making more series of statements today, is that if there's an exercise by statutory powers, so in other words, if any of these projects, any of these contracts are in fact suspended on the basis of a statutory power lockdown, I'm talking about, because that would have to come under a statutory instrument itself. Now we're actually talking about separately. That is something that will most likely cause a redress for a contractor in this particular instance. So therefore, if we're looking at, say, for example, in the event that the government response escalates and enhanced steps, most likely I'd be looking towards a relevant matter under the JCT. That's where the redress for money comes from, and that's under an event of 2.26.12. And that is a relevant event itself as well, under clause 2. So the difficulty when we actually see what actually occurs to the costs, we're back into the rules, certainly, of how projects are actually viewed by the courts. And we've often said in any of the seminars, the courts are not there to make a bad bargain a good one. If it's inherently a project or contract that can be performed, if it's one that can be actually, but it's substantially delayed because of these intervening events, there ought to be those positions for the redress, both in time and money. So this presents a huge considerable risk to contractors of how that actually arises. And when we arrive back into clause 2.1 of the JCT or any of those particular clauses, the risks are firmly placed on that point. So Diane's just after raising a question that she's after being asked. If you signed a contract now that you know the situation, does that mean the force majeure cannot be forced? How would you protect yourself? So if I'm reading it right, that you know the situation. So we have a foreseeable event and an unforeseeable event. And if you are inherently of the knowledge, we're now into a risk environment, and who has actually addressed that risk. So we're back into what are termed express clauses and implied clauses. Express clauses will always override the implied position. But if the event was known about and the circumstance was certainly brought into the contemplation at that time, certainly that would certainly be taken into account. But even then, just because an event is not foreseeable doesn't mean that the risk isn't borne by the inherent nature. They'll always go back to what the parties intended at the time of contract. Another question is, if a stand down was enforced, what costs would be allowable? I.e., if we continue to pay labour, would we get redress of that? So if we were to stand down, if it's enforced, so therefore we're talking about an instruction. So an instruction that follows under clause 311 or whatever it is under section 3 of JCT. And if there is an instruction provided that the parties are to, in fact, vacate the site, etc. Again, these will fall under the provisions, and the argument will be had whose risk bore that. And an instruction does not always entitle a party to time or money on it. It's just an instruction. You still have to meet what's called a relevant event. You still have to meet what's called a relevant matter. You must do that. So the argument would be that the instruction was required under the contract for whatever health and safety. It does not necessarily meet because the inherent clauses come about. It is an instruction. But if there is a point to say that there is a redress available and there is costs associated, and those costs have a causal link back to whatever the breach of the instruction, or that those events do fall under an intervening event, as we call, what you're actually entitled to in that instance is the losses, damages, if you like, and that would generally sit under the first rule of Hadley versus Baxendale in 1854, which is your direct loss and expense. So in any of these events, you're not particularly entitled to any more than you would have been had the contract been performed. So you're entitled to your losses in that respect. Now, overheads and profits will fall into those points, because if you actually get into a point of frustration, especially if you get into a point of force majeure, you will actually, those amounts would actually have become due. Because if we get into a frustrating event, the contract is destroyed. Contract can never be performed ever again. And again, the rules in Fabrosia in 1943 followed true. So another question moving on, I hope that addresses that. What about contracts for maintenance of building fabric and systems? If there's a monthly payment, for example, in exchange for regular PPM tasks, and those tasks cannot be performed as a result of a lockdown, where people are legally prohibited from attending the building, surely that's a temporary frustration during the period of prohibition. Now, to understand that we aren't in a situation yet, since the UK government has not made staying at home mandatory. Okay, so in terms of that, okay, so we've got two separate questions there. So again, we're saying a temporary frustration. It's not actually, it's an impediment, it's a prevention from those points. It's not frustration, it's actually an impediment. So in terms of that, your first starting point is to go back to the facility or the management agreement. Now, I've dealt quite a lot with management agreements in this place, and they simply fail to really deal with a lot of these issues in any event. Coming across quite a few issues in terms of the maintenance agreements, whereby it doesn't even deal with latent defects or doesn't deal with any of those points. But if you're prevented from actually gaining the access to these points, ultimately, under a maintenance agreement, one of your best positions would be under common law, as long as it's not excluded. And I say that without seeing the terms of the maintenance agreement, but knowing sometimes the contents. But ultimately, if there is an impediment, there's a prevention on those points, you certainly would have a redress, because you're entitled to go about and perform the contract. The very fact there has been a lockdown or you've been prevented from those points is a prevention itself. So who has to pay the damages? The principal contractor or the developer? Given the extraordinary circumstances, is it likely the judiciary would be directed to view COVID as a force majeure? Not necessarily. On the last point. So the last point I'll address, is it likely the judiciary would be directed to view COVID as a force majeure? I don't think so. It's not an act of God. It's pretty much, the argument will prevail that it's inherently man-made. I know there's been conspiracy theories floating around in relation to that. But when you have an interaction between different, I think this was bats in this instance, and the entering into the food chains. And even if you go into distinct allegations that have been made that, like, the wet markets of how the conditions and how those different points, that's inherently a man-made position rather than an act of God. I think that's the way that would be viewed. Going back to the first point, who has to pay the damages? The damages would be payable by the party you're contracting with. English law protects those parties, going back to 1915 and Dunlop. Privity of contract, it protects the parties who are not party to the contract, outside of the contract, from being sued. So therefore, your direct causal link will be those parties who are actually involved and and parties to the contract. It's not going to be a case of anybody third parties unless there's third party rights. But ultimately, if you are a subcontractor, you will be invariably going to the contractor. If you're a contractor, invariably going to the developer. But that's the chain, and that is where the losses actually arise. And I think it's important as well, like, when we talk about supply chains or design responsibilities, or how are those. So if any subcontractors default, ultimately, if you're in the case of a main contractor, you're inherently vicariously liable for the acts or omissions of those parties, because ultimately the main contract is formed on that as well. By all means, do keep the questions going. Diane has certainly put them, and she's keeping them passing through as quickly as it can, just to keep up with them. But even if we go back to, what do we do now? And I think that's going to be the certain point. If you're very lucky, that you could get an agreement going forward, that's going to be unlikely in that instance. Do watch out and do pay very, very close attention to what the governments are actually providing for. They've been very, very careful in their statements. The idea of going into a statutory power or a government-led position where they will actually provide a lockdown or restrictions, then that's going to cause a complete point. And I do think that in general terms, we do have instances where, if the agreement cannot be sought now, what do we do about it in the future? Remember, these are continuing points all the time, catch-all clauses. And it just actually is the question comes in now, do I think that the pandemic will change contracts in the future? This is pretty much the same question in terms of what was asked a couple of months ago. When we were talking about frustration, we were talking about force majeure, we're talking about all of these different questions. We were talking about Brexit at that time. And these are the new points. Back in 2009, we were talking about these with the swine flu, SARS, all of these different points. I think that it's certainly woken up quite a number of different points. You know, we'd spent quite a lot of time talking about terrorism clauses. So when we went through the whole different point of threats through the 2000s and even more recently, there was a big emphasis on what would happen if there was a terrorist strike around the site and made it absolutely impossible. There's no doubt about it that there will be an emphasis on many contracts going through. What I would expect to see now is that as contracts do go forward in the near future, of course, everybody's going to be talking about this. What's the net effect, like, knowing how does it run through it? But we have been there before. We've already suggested that, like, you know, the Brexit at the time, very similar conversation. It wasn't a frustrating event. It's not a force majeure. The contracts are still capable of being performed, although they're that little bit more difficult. But for the moment now, of course, everybody's going to be very emphasizing on this. We don't simply know, is this a 4-week problem, 6-week, 10, 12, what it is. So certainly parties will be respectively going out looking at their own interests. We've been asked, inundated in the last number of days. New contracts being entered into to start drafting force majeure clauses in relation to the pandemic as it stands, and how that actually runs through. Paul, that's you, is it? You're back on?
I'm on, yeah.
You've taken over now.
One question that I wanted to ask you, as you've called me out, is there any major differential between companies that are trading in the UK and in Ireland that we're seeing that is relevant at the moment, in terms of the approach for the government in Ireland and the approach for the government in the UK?
Is that in relation to the actual specific timing that we have now, is it, with the pandemic? Well, there's quite a few companies, like, no, obviously we've, being Irish, there's quite a broad spectrum. I act for clients who have a base in Ireland and a base in the UK, and inherently the rules are that little bit different. Broadly, they're the same. It's a difficult one to say. This is so new at the moment, and so many contracts are actually being performed. In some instances where parties are very lucky, they will get the opportunity. What I kind of notice is that we have this little bit of, dare I say, I'm not going to say knee-jerk reaction in some instances, but my biggest fear, Paul, would be this pandemic. The biggest risk, and something I'm very, very alive to, and I act quite a lot on, is rates, what the effects on businesses will have, both in Ireland and in the UK. Before this pandemic even started, we had some of the highest rates of insolvency with SMEs, and critically, there was about 2,300 in the construction industry alone. Like, no, only about 4 weeks ago, there was 3 northern companies that went down, owing 10, 15 million in each case to the supply chain. Generally, you'll find it's subcontractors and SMEs who get burnt quite quickly on those points. What we're actually suggesting, and what my fear with this is, that if this continues through, we have a real big problem with insolvency coming forward. And I do think that we have a real difficulty. We face really tough times, and we've got to be ready for it. I think there needs to be a supporting point of view when we talk about the risks with cash flow, what parties do with their actual own workers. But we already had a problem with insolvency in SME market, and the different efforts that we're putting in towards small companies. We feel that 80% of the work done on any given construction contract is by SMEs, and that's where generally all the work is done by. But they inherently are the ones that's really, really getting a tough deal. So we're trying to go back in and we're working very closely, as you know, Paul, with you, in terms of how we get in at the very start with the SMEs, grow them, use the banking, and actually use the knowledge that we all have to actually protect that. Another question. Again, I have a specialist subcontractor who has advised me that they will no longer be sending operatives to site due to the risks involved with COVID-19. The PC date, mid-April, will be jeopardized. Should I be notifying them that there may be potential of damages being levied their way? The same rules apply. We've been talking for quite a lot of the way upstream in terms of contractor going forward up towards, say, a developer. But conversely, the same actually applies downstream. So, and there's a case back in 1996, and this becomes, from this question from Darren, this actually goes back to a case in 1996, Davies, and essentially they tried to say that the contract was frustrated, and they tried to say the contract was not capable of being performed because there was a lack of resource, and I think it was labour strikes, a particular one. Now, that inherently failed. So just because a party will say, in the absence of any statutory requirement, it is only a recommendation to stay at home. It's not a mandatory point, but if they're refusing to perform the contract itself, we could potentially be heading into repudiation. But it's not a frustrating event. It's not a force majeure because there's a lack of any resource. So by all means, conversely, it goes the opposite way. Of course, you can levy if your contract allows for it, or if they run over time and there's liquidated damages point. Absolutely. If there's a clause in there that expressly provides for loss and expense on the basis of those, for sure. That comes down to the express statements of what the redress is. But because they're saying that they're not going to send labour to a site because it's not available, or refusal is not, so the same rules have to work downstream. Another question is, has any company got insurance for COVID-19 or any pandemic? The simple question is, if you're very lucky to have it for a pandemic, absolutely, and it will kick in. There is loss of business earnings. There's a lot of those points. I think if you don't have it by now, you would be looking at a very hefty premium. I think there would be probably a refusal at this stage. But a lot of policies do hold it. You have to be specifically, it's like an add-on or a top-up. Well, of course, yeah, and business interruption as a point of policy of insurance policies are certainly very achievable. If you check the policy wording really carefully, I would suggest, though, if that's the case, you probably might struggle to get a broker now to do it now, but absolutely, they're very much available. But going back to the point, Paul, like in relation, what do we see? This was an industry that was, like everybody was, it had already been hammered very poorly by Brexit. The exchange rates between Ireland, the euro, and the sterling had certainly had a huge knock-on effects as well over the course of time. We're going into a period of recovery. Following Brexit, we felt that there was this holding back of funds, that once it was brought into play, that there would be quite a release. Right at the very moment in time now, this is coming. So it's kind of a double whammy, and it really has taken quite a lot out of what is actually expected. We're talking about the difficulty in terms of property. What effect does this have? A lot of the properties that had been sold in Birmingham or any of these developments were actually by a lot of people based out in Hong Kong and Singapore. And we had sent out quite a few people in relation to that. It's probably where I ended up, getting being exposed myself at one point, but before Christmas. But those markets become very, very much under threat. And I think the big fear now is as the reality dawns that there is a potential recession. Again, I go back to insolvency is my biggest fear, cash strapped, and what's actually happening.
Okay, Henry, I'd like to, first of all, as you all well know, this is a very new portal that we are putting online. as our efforts to create a bit more awareness and raise some of the questions that are very topical and very, very urgently required in terms of information. So I'd ask anybody present to give us feedback on what you've heard. I would also ask you to contribute in terms of asking us other areas to actually get this type of information online. And what I would like to do also is make this, in particular, the area of finance that you might have heard Martin Mokler in the last hour speak about, and Henry in the legality side in particular. We will be doing repeats and updates on both of those subjects, I would hope, on a weekly basis, even though Henry has only just found that out now. I'd like to wrap up now, and thank you all for coming online. This is your portal. This is for you. The more feedback you can give us, the more we can create a success of this for BITA in times of challenging times. So be safe, and we'll continue to talk to you as we proceed with these online videography, Zoom fantastic events. Thank you.
Can I just say, Paul, thanks ever so much for that. Can I just say to everybody that this session has been recorded, and we will be posting it. If you've got any other questions that you want to pose to Henry or Martin, please send them to laura@bitter.ie. Thank you very much for joining us. It's been really good. Thank you for all your thank yous that are coming up in the chat now, and have a good evening.
Okay, thanks very much. Appreciate it. Okay, bye-bye.